Hello, and welcome to this presentation on justice, human rights and the International Criminal Court, Lessons from the Lord's Resistance Army War. I am Dr. Bryn Higgs, and this PowerPoint is based on my experience of community-based peacebuilding work in northern Uganda and southern Sudan from the year 2000 to 2006, and my research from 2009 to the completion of my PhD in 2016. I need to start by saying that on the ground in northern Uganda in 2004, as someone working for peace in the war there, I was initially hopeful that the International Criminal Court, the ICC, could help to end the Lord's Resistance Army War by bringing its leaders to trial. This presentation concerns what I learned about the relationship between justice, human rights and the ICC. I believe my findings are important for peace, justice and human rights workers in conflict regions. The slideshow is given in three parts. The first is about what we mean by justice and how the ICC fits into our ideas of justice. The second part uses the case study of the LRA war in Uganda, Sudan and beyond to understand what happened when the ICC brought its idea of justice to a real-life conflict. The third section identifies the learning that we can take away from that experience, observing similar issues occurring in other situations of the ICC's intervention. Let's start by looking at what we mean by justice. I want to put to you that justice is like a spider's web suspended between fixed points or poles. Each pole of the web of justice proposes a different notion of what is just, and no pole is enough to define the whole of justice. Each pole is essential for the web to be complete, but it requires the others for justice to be suspended between them. We will discuss four of the poles of justice today. Let's look at two poles of justice that relate to outcomes, a just situation. One of these is equality. Justice is incomplete without some understanding of equality, whether in relation to power, wealth or other commodities. Justice is deficient when some starve while others enjoy great wealth, or where some are held powerless in slavery while others wield great power and influence. But you can have too much equality. A rigidly imposed system of equality fails to reward human endeavour, excellence or compassion. We all benefit when a Stradivarius is played by a virtuoso violinist. I am glad when my children are rewarded at school for their skill, diligence or care for others. I would be saddened if acts of self-sacrifice and generosity were to be greeted with equanimity. Absolute equality in all things is not desirable. Equality is a pole of justice, insufficient in itself to define justice, but essential for its attainment. Another pole of justice is freedom. Justice is incomplete without social and political freedoms. Freedom of association, freedom of thought and expression, freedom to live where and as we choose, and so on. But one can have too much freedom. Freedom from taxes and the freedom to bear arms and the freedom to take or sell drugs are questioned by many. All would reject a Hobbesian nightmare of complete freedom to disregard the needs and rights of others. So we can see that freedom and equality are in tension. A world of rigid equality too tightly restricts freedoms that we cherish. A world of complete freedom would dispense altogether with equality. Both are essential for justice, and neither is desirable in its most extreme form. Two more poles of justice relate to decisions about how to decide what action is just. Consequentialism is a third pole, and it proposes that we assess just actions by their consequences. We know when an act is just by its impact upon the world. Utilitarianism and the writings of Jeremy Bentham, for example, propose just arrangements are found by securing the greatest good for the greatest number. This is surely a powerful measure of justice, but it is also flawed. Even when we know in advance the outcome of an action, the end does not always justify the means. A society delivering the greatest good for the greatest number could run upon slavery and might deploy torture, the better to enrich or protect its majority. Benefit to the greatest number is a powerful measure of justice, but in its purest form it is also flawed. A fourth pole of justice is deontology, as proposed by Immanuel Kant, which for our purposes we can approximate to adherence to just rules. Scholars of justice and philosophy will, I hope, forgive this shorthand. The adherence to just rules is very appealing as a measure of justice. In it we perceive the emergence of the rights of individuals and the notion that people should not be used as means to an end, but are an end in themselves. Let's consider an example. A rule against lying enables societies to function, to trade and operate, and for science to exist. Without such a rule, much of our communication becomes baseless. It is a pillar of social interaction. Yet even such a rule, if taken to its extreme, fails to deliver justice. Anne Frank could have been betrayed to the Gestapo by a truth-teller unwilling to depart from the just rule that they must not lie. Adherence to rules, even just ones, must be balanced by a consideration of consequences, if justice is to be attained. Too much obedience to the rules can lead to bad consequences. Regard only for consequences can violate people's rights. So the poles of consequentialism and rule adherence are in tension. Justice requires both concepts. Neither delivers justice in its purest form. They are in tension for just arrangements to be achieved. Crucially, none of these justice poles must triumph over the others. Each pole is needed, but no pole is right in its purest form. The notions of freedom, equality, or truth are emotionally stirring, but in their purest forms they deliver monstrous injustice. These most cherished ideals must be tempered by each other for justice to prevail. Emotions fuel our drive for justice, but intellect must overcome emotion so that a balance between poles can be found and justice attained. Now that we have touched upon some aspects of justice, we can consider where the ICC falls in the web of justice. The purpose of the ICC is to end impunity for international crimes, genocide, crimes against humanity, war crimes, and so on. It is intended that that will lead to a new international norm. Perpetrators of those crimes will always be punished. It will do this by applying the law, its own just rules. So while it has an ultimate consequentialist goal of reducing the levels of international crimes, its method is entirely based upon dispassionate application of rules. It applies the law regardless. Where it engages, the ICC's new approach applies to all interventions by the international community. None may defy it, all must assist. So all international interventions under the influence of ICC arrest warrants must now work within a new justice frame that is much less based upon consequences. The Court thus brings a new deontological or rule-based approach to these most complex and dangerous of situations. It represents a dramatic change in international emphasis. Where the stakes are highest, international interventions must adhere to just rules above consideration of the consequences of that intervention. It is an extremely bold departure from past priorities. The Court thus represents a dramatic shift by the international community. Whereas interventions in conflicts used to be governed by a mix of justice poles, balancing anticipated consequences with the application of the rule of law and other considerations, now the application of an unwavering rule that perpetrators of these crimes must be caught, tried and punished is central. The ICC implies that international engagements in these most dangerous situations is changing from a mixed approach to justice, in which consequences were often a primary concern, to a much more rigid application of legal rules. We can now consider the case study. What happened when this new deontological tool was applied in real life? Based upon my work in Uganda and Sudan from 2000 to 2010, and upon analysis by local peace groups and human rights organisations, and the PhDs of Branch, Dolan and Finstrom, I have three things to tell you about the war between the Lord's Resistance Army and the government of Uganda. The first summarises the conflict dynamic. The LRA was sustained principally by abduction. About 80% of its numbers were abductees. The UPDF, the Ugandan Army, was engaged in a war to kill the LRA, that is, the abductees. There was no significant effort to prevent abduction. The LRA could sustain its numbers by further abduction, so increased military effort simply ran the cycle faster. More killing by the Ugandan Army led to more abduction by the LRA. More abduction by the LRA led to more killing by the Ugandan Army. This was the first central dynamic of the LRA war, experienced by the community in northern Uganda for well over a decade prior to the ICC's engagement. This is a photograph of the memorial in Atiak, where the LRA committed a massacre of over 200 civilians in 1995 and abducted many young people to swell their numbers. They were able to commit these acts in a leisurely and organised fashion, largely unchallenged by the Ugandan Army detachment nearby. The second aspect of the conflict I want to mention is displacement of the population to the displaced people's camps. From the mid to late 1990s, and increasingly until about 2006, the population of northern Uganda was forcibly driven from their homes to the displaced people's camps. Up to 1.5 million people were affected. As they were principally farmers, many were made destitute by this process. Many children died in the immediate aftermath of displacement events, being the most vulnerable to malaria and other illnesses. This forced displacement was caused by two processes. Appalling LRA atrocities caused people to flee to the main centres, and the Ugandan Army drove people from their homes, also by force or threats of violence, using gunpoint or on occasion helicopter gunships. Both sides caused mass movement of the population. A World Health Organization study in 2005 estimated that this forced displacement was causing about 1,000 excess deaths per week. Displacement, the responsibility of both armed parties to the conflict, was the main killer in the war by more than a factor of 10. This picture shows Kalongo town, crowded with homes of displaced people from the surrounding countryside, forced to abandon their farms. People moving outside the towns and major routes were at risk of being killed by the LRA or the Ugandan Army. This then was the second main dynamic of the war as experienced by the population. The third principal element of the war related to the work of the community and its local representatives. Rejecting the LRA's claim to be fighting the government on its behalf, while abducting their young people, and the Ugandan Army's claim to be fighting the LRA on their behalf by killing their abducted family members, the local religious and traditional leadership established their own programming to end the war. They campaigned for and won an amnesty law in the year 2000 against the wishes of the President and the LRA. This enabled the return of abductees without fear of subsequent trial, as long as they abandoned rebellion. From 2000 onwards, they set about establishing that law as a practical reality on the ground, and communicating it to the civilian population and to those in the bush. In 2002-3, a trickle of returnees had started to arrive, fleeing the LRA and taking their chances to dodge hostile authorities and community members seeking revenge. By 2004, the trickle had become thousands. The LRA was significantly reduced, itself numbering only a few thousand at most. In these early years, it was obstructed by the government as well as the LRA. Each returnee evaded criminal justice for their crimes while in the bush, and each returnee was one person restored to society and no longer active in harming others. It was a pragmatic strategy. It involved closing down the LRA without killing the abductees. It was hugely cheaper than the government's war on the LRA and hugely more successful in terms of its reduction of LRA numbers, and it did not require the killing of the abductees. In terms of our understanding of justice, it emphasised a consequentialist approach. As such, it was distinctly different to the ICC's rule-based justice frame. And it was at this point that the ICC intervened in the conflict. The ICC entered the war on the side of the army and the government of Uganda. In order to secure arrest, it had to align itself with forces sufficiently militarily powerful that they might endorse and enforce its arrest warrants, and only the Ugandan army in this context promised anything like this degree of firepower. Tragically, the ICC intervened then against the community's effective non-violent peace strategy because it was consequentialist and pragmatic. Instead, it allied itself with the military, endorsing their war that was killing the abductees. This was an approach rooted in principle, not pragmatism. Furthermore, since 2004, we have subsequently observed the collapse of two peace processes, the Bigombe peace process and the Juba process. In both cases, for a deal to be signed, the leadership of the LRA would have to agree to be tried in court. This they have declined to do. With the ICC warrants outstanding, the future of talks to end the conflict seems closed. A decade of further war against the abductees has brought the arrest of one of the 5 indictees, Dominic Ongwen, himself a former abductee. The LRA is dispersed, mainly to DRC and the Central African Republic, but it continues at a low level to abduct, loot and kill civilians. In terms of our understanding of justice, the ICC implies a rule-based approach that requires often military enforcement. It is external, authoritarian, normative and rule-based, imposed by outsiders based on principle, not context or understanding, and is often delivered with violence. It has to be because warlords do not want to be arrested and will likely resist with violence. It displaces other approaches to justice that are local, flexible, consequentialist, pragmatic, non-violent, and in this case cheap and effective. The ICC makes no apology for this. In the words of the ICC prosecutor at the time, the issue is no longer about whether we agree or disagree with the pursuit of international criminal justice in moral or practical terms. It is the law. The prosecutor is not by any means alone in his view. Payam Akavan, an eminent professor of law who was involved in enabling the ICC to intervene in northern Uganda, states, "Although it may be desirable to take into account the concerns of local communities, the constituency of international criminal justice extends far beyond this local level. We must remember that community concerns in this instance, which he is fully aware of, is for the survival of their abducted children and youth, and that their remaining young people do not get abducted." Richard Goldstone, another prominent proponent of international criminal justice, notes in relation to the collapse of peace processes, "If in some cases ICC intervention is going to make peace negotiations difficult, that may be the price that has to be paid." Communities affected by the war in northern Uganda clearly took a different position. And returning to the former chief prosecutor, we can observe his vision for the future. "Armies all over the world prepare plans to arrest militia leaders." Apparently, this includes armies that drive people from their homes and hunt down and kill those who have been abducted. I, for one, do not share this vision. The humanitarian costs of ICC interventions, based upon its narrow and overly rule-based frame of justice, are mounting. In Kenya, ICC indictments of those most responsible for the 2008 post-election violence took place while they remained with significant power to mobilize violent security forces. The results were all too predictable. Witnesses and their families were silenced through threats or actual violence until the cases collapsed. In Libya, the principled ICC warrant for Gaddafi failed to take into account the likely consequences. and instead helped to legitimise the NATO bombing of that country. That precipitated the collapse of the Libyan state, with catastrophic consequences. In Sudan, the principled ICC warrant for Bashir has been much criticised. If he were to be arrested, some predict that it would clear the way for far more extreme elements to take control of the country. In Syria, the ICC's hand has been stayed. A principled warrant issued against Assad was considered, and indeed urged by some. Few now believe that such a step should have been taken at that time on the basis of principle alone, without regard to timing or its possible international consequences in relation to IS or US-Russian relations. These problems all relate to the same fundamental flaw. They have arisen because the ICC brings a single pole of justice alone, and because its process is not balanced by a consideration of consequences. It is causing great harm and great injustice through the application of its statute. If, in future, international interventions really are to promote justice, they will need to do so not on the basis of one pole alone, but upon an understanding that justice is suspended, as if upon a web, between different poles of justice. Each one is essential, and no single pole must triumph if justice is to be attained. I am carrying out this work to try to enable practitioners and policymakers to learn the lessons of the past. I welcome questions and comments. If evidence and intellect can be brought to bear on issues of justice, displacing military enforced principle that is blind to consequences, then in future more intelligent interventions can be made. Please can you help by recommending this presentation to your network, or contacting me to arrange talks or other dissemination opportunities. I currently need a budget of a few £1,000s per year to continue this work. If you know of someone willing to support this, to promote debate and understanding of this important topic, please recommend me to them and put me in touch. My email is brynhiggs@gmail.com. Thank you.